Hi, welcome back to Finally Revealed. In this episode, I want to talk about 4 financial terms that are somewhat interrelated. You may or may not have heard of these before, but they may pop up at some point, and I want you to be aware. The first 2 are personal liability and in rem liability. In the legal field, we have some Latin terms that have found their way in, just like they have in medicine. Personal liability means the borrower, or the person who's bought the thing, the person who has to pay or is agreeing to pay, has to actually pay it, meaning there is an obligation to pay money at some point. And personal doesn't always mean just a person. It means the person or the organization or the entity. So it's personal liability. If there's personal liability on something, it means that you can be pursued, you or the entity or organization can be pursued to actually pay. And if there is a judgment entered to enforce that obligation, then bank accounts and other assets can be attached to liquidate and have sold to get money to pay the obligation. The other kind of liability is in rem liability. This means property. When there is in rem liability, it means that the obligation will be satisfied or pursued to be satisfied only out of a thing. And usually it means real estate. In rem means when there's land. So personal liability or in personam liability is for money from the person, entity, or organization. In rem liability means that the property, the real estate, is going to be responsible for paying the debt or obligation. These now relate to the next 2 terms, which are recourse and non-recourse. Recourse means, and this is typically done in a borrower situation, borrower-lender situation, involving some type of collateral, whether it's a business and there's accounts receivable, or land, or it could be a trust or a personal loan and there is land or some other thing. So recourse means there is recourse back to the borrower. There is collateral that is pledged, but in addition to the collateral that can be taken or sold to satisfy the debt, the borrower or owner of the collateral can also be pursued for recourse. They can go back to that person or organization or entity and assert liability and pursue them for payment. Non-recourse means that while there is an owner, usually it's the owner, but a borrower, it's an entity, a person, or an organization is borrowing money or entering into some obligation where there's an obligation to pay, and there is a thing, a business, a certain asset, real estate or other asset that is pledged to secure the agreement, whether it's a loan or otherwise. And when it's non-recourse, it means it doesn't go against the entity, person, or organization. Again, they're only going to go after the asset. So recourse, non-recourse, in personam liability, in rem liability. If this was helpful, give me a thumbs up, leave any comments or questions below, share it with someone who it might benefit, subscribe to see the other videos, and come back and see me next time. Thanks for watching.